In this video, we're taking a deep dive into Section 28, Arbitration of Disputes, one of the most important and most misunderstood sections of the contract. This section, 1, explains how buyers and sellers choose whether disputes will be handled through neutral, binding arbitration instead of going to court. 2, defines what arbitration is and how the process works. 3, outlines the rights given up when parties initial the arbitration provision. 4, identifies which types of cases are included in arbitration and which are excluded. 5, shows how arbitration interacts with mediation and the order in which disputes must be handled. 6, reviews the protections still provided under California law during arbitration. 7, emphasizes why this decision must be made carefully since it affects A, appeal rights, B, jury trial rights, and C, the overall dispute resolution process. By the end of this video, you'll understand exactly what clients need to know before initialing the arbitration provision and how to explain this section clearly and compliantly. Let's get started with Section 28, Arbitration of Disputes. Section 28A, Agreement to Arbitrate. 1. The parties agree that any dispute or claim in law or equity arising out of this agreement or any resulting transaction that is not settled through mediation will be decided by neutral, binding arbitration, not in court. 2. The parties also agree to arbitrate disputes or claims with agents, if the agents agree in writing to go to arbitration before or within a reasonable time after the dispute is presented to them. Who is the arbitrator? A neutral arbitrator mutually agreed to by the parties, who may be a retired judge or justice, or an attorney with at least 5 years of residential real estate law experience, unless the parties mutually agree to a different arbitrator. What law controls the arbitration? 1. The agreement says the arbitration is governed by the Federal Arbitration Act and its procedural rules, not by the California Arbitration Act, even though California law still applies to the substance of the dispute. 2. The parties still have a right to discovery, as allowed by California Code of Civil Procedure Section 1283.05. 3. The arbitration is conducted under Title IX of Part 3 of the Code of Civil Procedure. 4. A judgment based on the arbitrator's decision can be entered in any court that has jurisdiction. Key talking point: if the parties initial this section, they are agreeing to let a private arbitrator decide disputes instead of a judge or jury, and that decision is generally final and binding. Section 28B, Exclusions, what is not covered. The following matters are excluded from mediation and arbitration. 1. Probate, small claims, or bankruptcy court matters. 2. Unlawful detainer actions, evictions. 3. Judicial or non-judicial foreclosure or similar actions to enforce a deed of trust, mortgage, or installment land sale contract, as defined in Civil Code Section 2985. So, even if this paragraph is initialed, these types of cases can still go straight to the appropriate court. Section 28C, Preservation of Actions, Protecting Deadlines and Liens. This section clarifies that certain court filings do not violate the mediation/arbitration agreement and do not waive those rights. 1. Filing a lawsuit just to preserve a statute of limitations. A party can file to stop the clock from running, then still go back to mediation/arbitration as required. 2. Filing court actions for interim relief, such as order of attachment, receivership, injunction, or other provisional remedies as long as the filing party files concurrently with or immediately after filing, asks the court to stay the litigation while mediation or arbitration is pursued. 3. Recording a mechanic's lien, contractors or others can record liens without waiving mediation/arbitration rights. How to say it simply: you can still file things in court to protect your rights or stop deadlines from expiring, and you can still record liens. Doing that doesn't mean you've given up the agreement to mediate or arbitrate. Section 28D, Agents. 1. Agents are not required to mediate or arbitrate unless they agree in writing. 2. If an agent does participate in mediation or arbitration, that does not automatically make them a party to the purchase agreement. This section gives agents the option, but not the obligation, to participate in arbitration. They're only bound if they agree in writing. Section 28E Notice and Initials. Rights you give up. This is the big bold notice block at the bottom that both buyer and seller initial if they agree. What it says in plain language, by initialing: 1. You agree that any dispute covered by this paragraph will be decided by neutral arbitration instead of a court or jury trial. 2. You understand you are giving up your judicial rights. No jury trial, limited rights to appeal, limited access to some forms of discovery compared to full civil litigation, except where specifically preserved in the paragraph. 3. If you refuse to submit to arbitration after agreeing to it, you may be compelled to arbitrate under the California Code of Civil Procedure. 4. The agreement is voluntary. Parties do not have to initial this provision. But if they do initial it, it is binding. 5. The notice ends with a confirmation statement, for which both buyer and seller initial. We have read and understand the foregoing and agree to submit disputes arising out of the matters included in the arbitration of disputes provision to neutral arbitration. Key message you want to convey to clients: initialing here is a big decision. You are voluntarily choosing binding arbitration instead of going to court or having a jury trial. This can be faster and more private, but it also limits appeal rights. If you have concerns, talk to a real estate attorney before initialing.